Hello folks, this is Chris outside the High Court in Cape Town, South Africa, where the case against expropriation without compensation is ongoing. Opening arguments today, the 3rd of August, taking place. Advocate Du Plessis for the Fatherland Foundation making compelling arguments that nil means nothing. It's shocking that anyone has to make this argument before a court of law. I mean, this is an abomination destroying the English language. It's pretty clear, nil means zero. And unfortunately, Section 25 of the Constitution guarantees just and equitable compensation under the Constitution. But this effort to undermine the rule of law in South Africa by passing a law that violates the Constitution is a clear abomination. Speaking on behalf of AfriForum, Advocate Havenga made it very clear in his opening remarks that AfriForum was not contesting the constitutional prerogative or obligation at land reform, but rather the constitutionality of this law. In other words, AfriForum says that land reform under the Constitution is necessary, but this law is unconstitutional. It doesn't take a constitutional advocate to understand Section 25. It's clear, it's obvious to anyone who reads the law or that section of the Constitution what it means. Just and equitable compensation agreed upon by both parties. Also, interestingly, as his argument, the opening argument continued, Advocate Havenga also made the position that traditionally expropriation was the government taking from a private citizen and retaining land for the government's use. Obviously, this is akin to eminent domain in the United States, where the government takes land and uses it for railroads, ports, national parks, things that are in the public interest. But in this case, South Africa is making the situation where the government takes land from one party and gives it to a third party. Now, there are legitimate arguments under South Africa's Constitution that this is necessary. However, it does require just and equitable compensation under Section 25 of the Constitution. And that is clearly being ignored. As I said, 3 August 2026, the opening arguments in this case for a law that was signed by Cyril Ramaphosa surreptitiously in December of 2024, and then to great fanfare signed it at the World Economic Forum in Davos in 2025. Expressly giving the government the right to expropriate property, not land, but property, at the national, the provincial, and the local level. Any official, without any justification whatsoever, can now confiscate your land under this law, which to me is unconstitutional, and that's what the arguments taking place here at the High Court are all about today, determining whether it's constitutional or not. It's clearly unconstitutional. The bottom line with this whole situation, folks, is that the government has given itself the right to take land or take property, which can include stocks, bonds, crude lands, vehicles, apartments, houses, any property that you own, and give it to a third party without justifying to you why they did it. South Africa, of course, is a signatory to the Universal Declaration of Human Rights. While not a legal obligation, it is a formal recognition of natural rights given by God and the right to possess private property. South Africa, under the ANC, is a signatory to that document, Universal Declaration of Human Rights. So that is violated, the spirit of that, as well as the Constitution being violated under Section 25. We'll see what plays out here in the court as this goes forward. Reporting from the High Court in Cape Town, this is Chris, wishing you all a lovely day.